Hello, everybody, and good morning. My name is Erin Kopek, and I'm the VP of Sales and Marketing with Higher Level. And today you have joined our workplace webinar, the HiNotes. We have been running this program, I would say about 13 years now. I started it and have just loved to see the growth of it and all of you attending and spending your mornings with us. Today we have a great speaker. We have Andrew Metcalf with Ogletree Deaconess, and he is a shareholder with the firm and has been a speaker year after year. Andrew, I don't know if this is year 5 or 4. You lose track of time after a while, but love bringing him back and letting him share his expertise with us. Just a few housekeeping things before we get started, just so you all kind of know what to expect today. It'll be a little under an hour. The presentation will be today. You will have opportunities to ask questions throughout the presentation, so feel free to pose your questions on the question or the chat function, and I will relay those to Andrew, and we will answer those the best that we can today. So looking forward to hearing this information and always the great value, Andrew, that you bring to us and our group. So before we get started, a brief intro on Andrew. Andrew Metcalf is an employment law and shareholder at Ogletree Deacons. He defends businesses and workplace lawsuits in court and before administrative agencies. He also advises employers on a broad variety of workplace issues, including religious accommodations, FMLA leave, investigations, and more. We could go on for days about Andrew's accolades and experience, but I will let him share that with you. And thank you for joining us, Andrew.
Yeah, Erin, thank you so much for having me, and thanks to all of you for being here virtually so we can continue these discussions and education and thinking about issues that matter to you. As Erin and I were talking about, what do we give you all? What do we present on? What kind of topics would be useful for you? I had 2 goals. One of them, can we try to do a non-COVID topic? Because I think everyone's tired of it. And there's a lot out there on that. And one thing that I thought, and Erin agreed, would be useful for you all to maybe think about is your attendance policies and potentially revamping those or hitting the reset button on them. And we'll talk about why that is. But we felt that while this is a topic that you're all already familiar with from day-to-day management of your attendance, there are a lot of different things that different companies do to manage attendance in different ways. And so in this presentation, I'm going to talk about what those are and different pros and cons to those approaches. And also, since I'm a lawyer, I'm going to be talking about what that stuff looks like on the other side in a lawsuit. So I see these things play out in court. I see these things play out in lawsuits that last for years, litigation over attendance policies and attendance policy issues. We're going to go over real cases and real examples of what some of the risks are with respect to enforcement of attendance policies, so that in preparing yours and in enforcing yours, you can have an idea of what it is that you want to do in order to in order to have the right kind of culture that you want, and in order to have the right kind of disciplinary procedures that you want and that are right for your particular organization. So that's why we wanted to talk about this. One of the reasons is I'll talk about and what we're going to do today. As always, this is not legal advice. This is not confidential. You should not ask confidential and should not ask things that you aren't comfortable with other people seeing. I see my video may have just went out, but hopefully you all can maybe see me in a sec once I plug it back in here. But hopefully you can still hear me. I know Erin would interrupt me if not. So
we can hear you.
So I want to make sure that you're thinking about these things so that you can. My goal is that you leave with this with some good examples and with some good opportunities to potentially improve your policies and to alter your policies as necessary. At the end of the presentation, I've got a couple sample policies that I've copied in here. I could give you copies of those as well as you go through it. So with that, again, my name's Andrew Metcalf. I'm a lawyer. I do employment law. I do workplace law. So I'm dealing with this stuff every day in a couple different capacities. I advise clients day to day on what their policies should be, how they should apply their policies, and disciplinary issues. And I also litigate these issues in court. So when an issue happens that, you know, you need to deal with and your company needs to deal with, like a lawsuit or an administrative action or something of that nature, I help clients deal with those. So I have a lot of experience seeing different types of attendance policies of companies, seeing what they look like, seeing what companies are doing, and then also helping them develop theirs and then defending their decisions in court. So in the olden days, does anyone remember how attendance was monitored? Some of you on this call probably recognize what this is, right? The old time clock, primarily used for, of course, clocking when people are in and out for purposes of pay, but it also created a really easy way to monitor attendance and when people were coming in late and when they weren't there, right? So it was a dual system. It worked really, really well, but we don't use these things anymore. I have actually, despite how young I may look, I have clocked in on one of these, not necessarily because I'm old enough to have used one, but because my employer was a little behind the times, I think. This was maybe 15 years ago when I was in high school working at a warehouse over in Earth City. Have you, many of you have probably used these, maybe click in the chat. I would love to know in the chat, you know, who you are and where you're coming from, and you can say whether or not you've used one of those time clocks in your day and how long ago it was. Please introduce yourself in the chat. Let us know who you are and where you're from, what organization you're with, so we can say hi to you. And as Aaron said, feel free to drop questions in the chat. If I don't get to them during this, I will do my best to get to them at the end when Aaron and I open it up a little bit more. But obviously we don't have these anymore to monitor attendance. And so what has happened since employers stopped using these? Well, it used to be, I find, even when I started doing employment law 10 years ago, the clients that I worked with tended to rigorously monitor and enforce time and attendance and tardiness standards. But there are problems with that, right? If you're going to have rigorous time and attendance standards, what are you going to get? Well, one thing you're going to get on the negative side is employee pushback, right? Employees don't like being held necessarily accountable to some of those time and attendance standards. So you may find yourself in situations where you have told an employee, hey, this is our expectation and this is how you're not meeting it. And the response, of course, from the employee might be, well, wait a minute. No, like you shouldn't discipline me for this because of this reason or that reason. And what ends up happening is you end up essentially litigating disciplinary issues in-house, I like to say, right? You kind of get this, you know, lawsuit, you know, within your company, sort of, where you're talking to people about what the standards are and they're pushing back saying, well, I don't agree with those, or I don't agree you're enforcing it right, or I don't agree you should be enforcing it. And all of those obviously might be dealt with in different ways. But that's one reason why companies have probably been less stringent, I see, in recent years about monitoring and enforcing time and attendance policies. Two, they're too difficult to deal with, right? Due to absences that might be excused under the Fmla, the ADA, workers' comp policies, whatever it is. And we're going to talk today about how to deal with that. But you might say when someone's out for a reason that could be a disability or a medical issue, well, we don't feel right enforcing our policy with respect to them. And you may be right in that approach. And we'll talk about how to monitor and deal with that. Recruitment concerns and culture concerns, I'll put on that same line. A big issue with these is if you're going to enforce these, are you going to lose people that you don't want to lose? And a problem is, you know, is your attendance policy too stringent or not stringent enough? And if it's too stringent, a concern that you may have and an issue that you may have is that you're offboarding a lot of people due to involuntary discharges because they've violated your policy, right? And you may not necessarily want to do that. Every call that I'm on, right, as a lawyer with clients, we're thinking often when I'm giving advice about the recruitment implications of the advice that I'm giving. And that's tough, right? That's difficult. And that's something that we need to be considering. Do you want to have disciplinary policies that may result in exacerbating recruitment and retention concerns within your organization? Even if you don't end up involuntarily discharging people under an attendance policy, you're well aware that an issue that is going to come up is that when you are disciplining people for attendance issues, they're going to be disgruntled about it potentially, and they may not respond well to it, and they may not want to stick with your company. So it's this constant back and forth, right? And that shift of the balance of power has definitely gone towards letting employees kind of have the power in their time and attendance, or have more power than in those olden days when we were punching the clock and maybe being more stringent about it. Finally, taking into account the final thing I want to mention is that time and attendance policies do take a lot of work to enforce and do take a lot of precision to enforce. You need to have probably a dedicated person, be it departmental managers or someone in an HR administrative function who is going to be monitoring that. And it takes time, right? And you may not want to do that. And so that's something else to consider, that a policy is only good as how you enforce it. You can write down the best attendance policy in the world, and it's going to be absolutely useless if you don't have someone in your organization who is the captain of that policy and who is in a position to enforce it. So that's something that you need to consider in thinking, do we want to try to shift power back to the company and have a policy related to attendance, because it's going to take time to enforce if we're going to do this right. If you have a policy and don't enforce it, that's not going to help anybody. It's not going to help the company reach its goals. It's not going to help employees know what expectations are, because one thing's going to be written down and another thing is going to be done. I see all the time company policies don't reflect what actually happens in practice, and I think that can be a big issue. So when writing down policies, you may write down a great attendance policy and think, this looks great on paper. We're going to do all this. We're going to enforce this. But then in practice, is the person who's actually enforcing that policy looped in on the process of drafting it? If not, are you sure that that person is going to have the time and wherewithal to make sure that the policy is enforced? It is a problem that I see very often. In virtually every lawsuit that I have, I get the company policies, and when I'm looking at them, a problem that comes up is that the practices don't necessarily conform with the policies. It comes up with investigation policies all the time. Investigation policies will say, oh, the CEO or the vice president of HR, someone will investigate every allegation of harassment. Well, what does that mean exactly? If someone gets disciplined and says, oh, this is because of my age, does that trigger an investigation or not? And who conducts the investigation? Is it really that person there? The same issue happens with attendance policies. It's very common for companies to write something down that looks beautiful on paper, but in practice isn't something that can actually be enforced. So with that, I want you to think about, should you care about having an attendance policy in your organization that is more robust than whatever you're doing now? Does it make sense to have an attendance policy if it's not going to be followed in practice? And do you need to have an attendance policy if it seems arbitrary to employees? In today's work environment, blending, especially for exempt employees, the work from home and remotely versus the work in a traditional work environment, if employees are getting work done, do you need to police their presence? Or is it going to be better to address those on an individual basis? And you can still have an attendance policy that gives you the flexibility to do that, as we're going to talk about. So think about whether, for your particular work environment, who is this attendance policy going to apply to? It doesn't need to apply to everybody. You probably should have an attendance policy that may be different for those non-exempt employees performing, more routine tasks versus your higher level or administrative or executive employees who are working odd hours and are exempt and may have different expectations as far as what their attendance is. Another thing to consider is, will an attendance policy, if you roll it out, seem demeaning and draconian to your workforce? And if so, you may want to think about what your attendance policy looks like. If you haven't had one, and you just throw a very stringent 4-page attendance policy on your workforce, you can expect that hearts will sink when they see it and think, oh my gosh, now I'm being monitored every second that I'm here, and what's the reason why this is happening? And so presenting it in the right way can be important. And again, we'll talk about different types of policies, flexible versus non-flexible, so you can think about what is right for you insofar as the strategy for enforcing that. And then think too about who this applies to, right? Your exempt versus non-exempt employees. How are they going to be treated? How are different job classes and job titles going to be treated? It probably doesn't make sense to have an attendance policy that applies to everyone from top to bottom the exact same way. There are certain different groups of employees to whom they should apply. And of course, the policies should be well published to those groups of employees so that they know what the expectations are for their positions. Finally, of course, I'm not going to talk too much about unionized workforces in this, but obviously, if you are having an attendance policy and consequences with respect to discipline that likely is going to be a subject that is going to be bargained, that is going to be dealt with through grievances from the union. And so their buy-in on the policy and their understanding and agreement to it is going to be something that's going to be important before you roll it out, because it is going to be a mandatory subject that needs to be bargained. So with all that, I've covered the negative side, and you might say, okay, well, do we need to be here for the rest of the presentation? I don't want to do this, right? Not so fast. What are the benefits to having an attendance policy in your organization that is well thought out, well written, and well defined with respect to what the expectations are? Well, number one, it sets expectations and gives employees a fair chance to meet them. Why is that important? Why is that important from my perspective as a lawyer? It's because when you let someone go, when you fire someone involuntarily, I like to have as much as possible documentation that we can use to explain to outsiders, a jury, how your company works, what your company values, and the process that your company uses for dealing with issues. And jurors expect you to have that kind of documentation. So what is very helpful is for you to have a document, a policy that we can point to and say, this was the rule, and here's how we put the employee on notice of it. We put it in a handbook. We put it on an online system. We emailed it to this employee. When there was an issue, we specifically gave a copy of it to this employee to say, make sure you know about this and make sure you're following it. That's great, because that policy is now backup. It's not just that you're setting arbitrary rules as a manager that apply to one person. It's that you've thought about what the culture is going to be for attendance in your organization, and you have that in your corner to use later on as Exhibit A. It's going to enforce those expectations, and it's going to be used in court to explain to outsiders what the expectations were for your company. It also helps us show when those expectations are obviously violated, right? We should be able to say the attendance policy required this person did that, therefore we have a violation. It should be very clear. And in that way, your attendance policy is also sort of your backup and a witness that you're going to use at any sort of trial or disciplinary proceedings over an attendance issue. So, with your attendance policies, when we're using them as exhibits, they're sort of a witness that's going to testify for you and for the company. The attendance policy is going to speak for itself, and it's going to back up decisions that you make. So think of your attendance policy when you're in disciplinary meetings as your backup, right? It's your fellow sort of police officer who's there in the interrogation or meeting with you, right? To give you that extra support and say, look, it's not just me coming down on you. This policy is what's coming down on you. This policy is what needs to be followed. This is the expectation. So it's your backup, and we should use it as such. When employees don't meet expectations, of course, the attendance policy provides a roadmap for correcting behavior. It's something that you will want to give to the employee physically and say, this is the expectation. This is what you haven't been meeting. These are the consequences that you're facing now. And look, this thing says what the consequences are going to be later if you continue down this path. Don't continue down this path, go down this other path. We want to give those types of chances to employees because showing fairness is really important in lawsuits later. Jurors want to see that we gave people notice of their issues, we let them know what expectations are, we gave them a fair chance to succeed, and they didn't succeed if we ultimately had to go down the discharge path. Sometimes too, having a specific and rigid attendance policy can, do a good job at creating a black and white reason for termination. I find business leaders in HR want to follow their policies like laws. I don't necessarily see them that way all the time, but your attendance policy maybe can and should be, because that's going to be a very black and white rule that you can set for your organization and make sure that people aren't underperforming, based on attendance concerns, and to say, look, we have a very bright line of what's a violation and what's not, and what happens when a violation occurs. So that's the standard you need to meet. And because you haven't met it, this is nothing personal. It's just the numbers, and what we're seeing here, you're facing these consequences. Now, what types of attendance policies might you consider having? I basically want to break them down into two different types, which you're probably familiar with to some extent. The first I want to talk about, of course, is a points or occurrence-based system where employees who are absent arrive late or they accrue points and discipline depending on what level they are at in your attendance policy. So the policy says, this is what you accrue points for, and I have a sample of this in the presentation that you can have. This is what you accrue points for. This is what, what is going to happen when you accrue those points, and what you can expect as far as discipline and as far as corrective action. These policies can be great because, again, they help set those uniform bright line rules, and they make your job really easy. All you have to do is track the points and let people know when they haven't met them. They're great for groups of large non-exempt employees where you have to manage attendance for a lot of similarly situated employees in a similar situation. Some cons of these policies, they may lead to undesirable consequences for violators. You may not want to terminate people so quickly. You may find that they've accrued points really, really quickly due to some sort of big absence, due to a reason that you say, hey, we want to excuse. And you may feel that your policy may not give you the latitude necessarily to do that. I'm also going to talk specifically about risks related to these policies, which are also sometimes called no-fault policies. And they're called that because when you're assessing points, you don't care why the employee isn't there. You don't care whether it's the employee's fault or not, essentially, but really you're not going to hold the employee at fault depending on the reason for the absence. You're just going to say, look, we understand you're going to be gone sometimes. There's going to be consequences for that, but as long as it doesn't happen too often, the consequences will be somewhat minimal, right? So that's how this works. And that's where the no fault sort of terminology comes from. And I'll talk in a minute about why that can be legally problematic in certain situations. The other thing to ask is, how does this attendance policy, this type, interact with other progressive discipline policies? You may not want to have a situation where employees accrue a final written warning because of how they deal with someone else in the workplace, and then they're fired the next day because of one no-call, no-show, their first in a year, right? That may not be fair. So often companies set these points-based attendance policies on a different disciplinary track than the other issues that may happen in the workplace. You don't have to do it that way, but that's often because of how unique disciplinary attendance issues are, how employers are doing that. So think carefully how it interacts with other progressive disciplinary policies. And of course, you'll need to think carefully about how are the attendance occurrences going to roll off, right? It's not that they're going to stay on someone's record forever, because you don't want to terminate a 30-year employee because of 10 absences, right? Or 10 attendance points. So they're probably going to roll off after a year, after some defined period of time that's appropriate for you, so that you're addressing attendance issues expeditiously and fairly in your organization. So I'd encourage you to think about that, and consider having what kind of window you want. And there's a lot of latitude there so that you can give discipline at the pace that makes sense for your organization. Now, the second type of attendance policy I want to talk about is just a more open-ended one that really doesn't set any sort of thresholds for what will happen and when in any sort of lockstep, rigid way. Instead, it would just be a policy that sets your expectations as to what attendance is, says how important attendance is, and says that if there are recurring issues with attendance or tardiness, that's something that you might address. When you do address it, you may want to impose a more rigid expectation on employees. You may want to give them a performance improvement plan to say, hey, we've noticed a pattern here. This is what we see. These are the attendance, issues we're seeing. At this point, we need to see in the next 30 days, 0 attendance issues, or else it's going to lead to further consequences. And, you may want to define that and sort of transition to a more defined policy when someone is engaging in that type of performance issue that you need to address. That's permissible. The benefit to this is that you don't have to police it as much until there's an issue. The benefit is that especially if you're a small organization and you want to be flexible with employees, you may feel that you can give them more leeway without a more draconian approach of giving discipline along the way or early on, and then only address issues when they become really apparent. This can be more appropriate for those exempt employees who are coming and going and doing their work maybe at weirder hours or on their own schedule, essentially. So if you want to allow that, this could be something that you do. And then when issues come up, for example, someone starting work late, you address it with that person specifically, set what the specific expectation is, and let them know that if they continue down the path that they're on, you're going to need to address it further. The risk of this type of policy, the primary con, is inconsistent treatment. Very often, one thing that we see in disciplining employees and in lawsuits later is that one ways that employees who are not meeting expectations deflect issues is that they tend to say, well, let's not point the finger at me. What about all these other people and all their issues? You're not addressing those. You're only coming at me. So how often when you discipline someone do they do that? One of the excuses is, well, it's not my problem. It's everyone else's problem. That might be something that you get, and particularly with an open-ended attendance policy, is someone who sits down and says, well, you're coming at me for coming in late every day, or for clocking in late, or for not being here, or for being no call, no show. But what about this person? They were missing on this day, and that person who is missing on this day, and this person who is missing on that day. If you have a points-based system, you can say, ha, we're tracking all this, and we know you have a bigger issue here. But if you have a more open-ended policy and you aren't tracking it as much, it may be harder to rebut that on the spot and to say you're treating other people fairly. And you may need to go back and look and say, okay, they say all these other people are late just as much. Is that true or not? And what records do we have to prove that? And so that may be something that you need to do to prove and show consistent and non-arbitrary treatment. So another form of attendance policy that I've seen, particularly in recent years, among some really cool employers that I've been blessed with the opportunity to work with, are sort of gig staffing agency models for their workforce where, if you're employing a lot of employees, people are essentially allowed to pick up whatever shifts that they want. And there aren't really consequences for not picking up shifts unless you sign up and then don't show up. So there's still consequences when people sign up for the shifts and don't show up. Right? Or if they, if they don't let you know a certain amount beforehand. But I've seen some employers have really interesting models where they essentially have a gig type workforce. And this can be really effective to do in conjunction with your staffing agencies like Higher Level. And essentially, again, they're employing a ton of people and they're not necessarily expecting people to sign up for that many shifts. They can sign up for as many as they want. And, they only get attendance points if, say within 4 hours of a shift, they call in and say, oh, I can't be there. But if they open up a shift more than 4 hours before, the company feels that they have that workforce behind them to staff the shifts. And so as a result of that, they don't feel the need to come down on employees as often for staffing issues. If people don't want to work or they have issues, they just shouldn't sign up for the shifts, or they should cancel their shifts far enough in advance. The cons to this obviously is you don't have as consistent a workforce potentially, that you don't know who's going to be signing up and who's showing up. And you may only impose those consequences if an employee doesn't pick up shifts for a long time. Say an employee doesn't sign up for a shift for 2 months, you may say, hey, you're no longer employed with us. Another obviously big problem with this are employees who may want health insurance but don't work enough. Unfortunately, the health insurance system restricts us in classifying people as part-time and full-time, and there are consequences if people aren't working typically more than 30 or so hours a week. And so with this type of workforce and this type of attendance policy, you may run into those issues. But it's been something really, really cool. Again, I've seen from some really innovative employers that say, look, we don't want to deal with scheduling and attendance issues as much anymore. Work when you want. We feel we've got enough people on the payroll technically that we can afford to let you off the hook. And obviously there's other cost implications to that you need to be thinking about with respect to how many employees you may have on staff. But it's been a really interesting model that I've seen. Okay, now I've said that there are problems potentially with those no fault points policies. So let's talk about the potential fault there. And again, I refer to those policies as one where you aren't holding employees at fault based on the reason why they're absent. You don't care, you don't ask, they don't need to tell you, they just don't have to show up. And if they do, they suffer whatever consequences, a point on their record, perhaps. And that would seem to be very beneficial to employees and to employers. If you have one of these policies, don't necessarily need to get into the dirty reasons of why people aren't at work or police that. You just say, look, whatever it was, that's okay, up to an extent. We'll keep a record of it, and if it becomes an issue later, it's something that we'll deal with. Here's the problem. The EEOC sees no fault as a bad word, as a bad phrase. What the problem that they see is potentially is that if employers aren't asking and diving into the reasons why employees are absent, they may be assessing attendance points without assessing whether someone needs the absence due to a disability or a serious health condition under the FMLA. And the EEOC's position is that if someone needs an absence due to a ADA qualifying disability, we need to assess as an employer whether it would be a reasonable accommodation to give the employee that day off. So the ADA and equivalent state laws generally requires covered employers, 15 or more employees at the federal level, to provide reasonable accommodations to people with disabilities. What that means is you have an obligation, you have to, it's not a choice, make modifications to the work environment in order to make that environment accessible to people with disabilities. One type of accommodation that is suggested under the EEOC regulations and required for you to consider is a reasonable amount of time off work. Okay, now that I've given you that mini crash course on the ADA, how does this come into play and create a problem with no fault attendance policies? The problem is with the no fault attendance policy, if you are not asking employees why they are gone and assessing whether it would be a reasonable accommodation in order to be a reasonable accommodation to give the employee that time off, you could run into a problem because you could be assessing points and terminating people for absences that would have been reasonable to give to employees as an accommodation. And so we're going to talk about how to deal with that and strategies for addressing that. But before I get into that, I always love telling stories during these. I love you all seeing actual real life case studies. So let's get into a few of those before we go more into solutions. So I want to talk to you about a case where an employer denied a 19-year employee's request for an accommodation in the form of intermittent leave. So here's what happened. The employee was absent 5 times due to treatment and hospitalizations for a variety of issues: COPD, chronic bronchitis, chronic bleeding, and high blood pressure. The employer saw those absences and just discharged the employee. The employee ended up facing a lawsuit because the ADA requires employers to provide employees with disabilities absent and undue hardship. It's unclear how that one played out, but what could the employer have done here? Dig into the reason for the absences, even if you have a no-fault policy. And if employees are out due to reasons that may be a disability, address those right away. Don't let it fester. Say, okay, we're on notice of this. That was a problem that you did that. Maybe it's reasonable to give you 1 day off without notice, but what are we going to do going forward? Because we can't just have you saying, even if it's due to a disability, oh, I'm not showing up today, or telling us 5 hours after your shift starts that you're not showing up. That's an issue. So what expectations can we set that are a reasonable accommodation for you that are going to allow us to meet those attendance expectations and that are also going to allow us to hold you accountable, but also to give you reasonable time off if it is necessary? All right, so what do you need to be considering? You need to be considering that if you are FMLA covered in particular because you have 50 plus employees, when the employee puts you on notice, potentially through an absence, that they may have a serious health condition, you have that obligation within like 5 days to provide the employee with that notice under the FMLA about whether they are eligible for FMLA at that point or not. You can still assess later on whether it is appropriate to designate their leave as FMLA. But the second that you have notice of that they may have a serious health condition, you need to give the employee notice about whether they may be eligible for FMLA so that you can continue exploring whether they're taking time off due to a qualifying condition that you may need to accommodate. Here's another solution here though. If you have that points policy, you may be scared about saying, oh my gosh, so now an employee is on FMLA, or I've granted leave as a reasonable accommodation, and now I'm never going to know when the employee is going to work, right? They're going to call me 5 hours after their shift starts or not call me at all, or I'm going to find out at the last minute and then I'm going to have to scramble to get somebody. The solution is that the FMLA allows you and doesn't prohibit you from having policies that require employees to give notice of their need for leave and to give reasonable notice. So this is something I want you to put on your to-do list right now. After this call, check your policies, check your FMLA policy, check your leave policies. Does it have provisions that instruct employees on what they need to do in order to put the company on notice of a need for leave? And do you require that as far in advance as you want? Now, if the employee has an emergency and can't give you notice right away, then the employee could still be entitled to FMLA. If they say, for example, I had to be hospitalized and I couldn't get back to you right away. Okay, well, that could be a reason why you need to grant leave despite your notice procedures. But you're only going to know that if you dig in. So if someone doesn't give you proper notice as required by your policy, you should be asking them, well, wait a minute, why didn't you give proper notice? And if they don't have a good reason, you can document that and you can dock them for it, right? You can address that under your attendance policy. Sure, there's risk, right? But if you get the right information from the employee to verify whether or not they actually could have given you notice earlier than they did, then you'll be in a better position to enforce your policies and in a better position to hold employees accountable for not following those policies. The other thing that's going to put you on notice or in a better position for enforcing these policies is when employees need time off due to a disability or due to FMLA leave, are you giving them information about your policy that gives them the high points of what they need to be doing on their leave? So I've always thought, if I ever work in-house with one of your companies, if you want to hire me, that's great. I'll gladly always work anywhere for more money and less work, right? But I've been here 10 years, so so I like it. I like doing what I do. But if I ever work in-house at a company, I'm going to make sure for any employee going on FMLA leave or any other type of leave, we're giving them a one-page sheet with bullet points of what we expect from them and what they expect from us. It's going to tell them, you should expect as an employee that we're not going to bug you. This is your time. You should cherish it. We cherish it. There are things more important than work. We value you using this leave benefit that we're giving you, maybe because it's required by law, but we still value it. And so, we expect no one's going to contact you about work. If you are contacted, let us know so we can tell that person not to bother you, right? Why is that important? Because when employees are bothered on FMLA leave, they can bring an interference claim saying, hey, I was on FMLA leave, but they kept calling me every day, right? Because I'm so important. That's not good, right? And that can lead to an FMLA violation. So you may want to give that sheet. But another thing I would put on that sheet is a bullet point that says, if you are, going to be gone, you need to give us this kind of notice. If you're on intermittent leave, you need to tell us at least 2 hours before the shift or a day before. And if you can't, you need to let us know why you couldn't let us know. Why is that helpful? Because then you can hold employees accountable. You can say, we told you, give us notice. You can say, we told you who you needed to contact and what you needed to tell us and by when you needed to do it. And if employees are late at doing that, you can come down on them and say, hey, this isn't fair to us. You can't let us know last minute that you're going to be off because it puts us in a bind. We've got to scramble to find somebody. That's an issue. That's why we had this policy telling you, don't do this. Right? Let us know earlier. And so I'm getting amped up about this because I see you all don't do it. And then we have a problem later when you call me and you say, we want to fire this person because, gosh, they just let us know at the last minute all the time that they're off and they're not giving us notice. And my first question is, what did we do to put them on notice that this is an issue? What did we do? And what can we do to let them know that, hey, this is our expectation? What is going to be Exhibit A if we fire this person? What am I going to hold up in court and say, see, jury, we told this employee personally, this is what the expectation is. And then we document it over here when the employee didn't meet that expectation. And then we got their excuse and it wasn't good enough for us. It didn't meet our expectations. So that's why we had to take the action that we did. This is part, your leave policies and attendance policies need to be harmonized, but that notice requirement is a key tool that not enough employers use. And so I want you to realize that's one of the arrows in your quiver that you can have in order to have the kind of situation with attendance at work that you want. Remember too, as you're excusing people from being there due to disabling reasons or due to medical issues, even if they don't qualify for FMLA, and you're really thinking about whether it's a reasonable accommodation under the ADA, many courts have said that regular and reliable attendance is an essential function of most jobs. And so if an employee can't define how often they need off due to a disability and can't tell you, how often they're going to be not there, that could be an issue. And so you can work really, really closely with employees to understand, okay, you're telling us you need off due to a disability. When? How often? What can we expect? Right? Give us the best idea you can. And if employees can't do that and they're off for extended periods of time without much notice or without a reasonable cadence, you may be able to say, look, it's not a reasonable accommodation to let you do this because it's putting a lot of work on other people. And so as a result of that, we can't let you do this. You need to either come up with a different schedule for this, or we need to talk about a different position for you or a part-time position or whatever it is that is going to enable you to stay in the workforce. And if there's truly nothing we can do to keep you in this workforce, then at this time we may need to end your employment relationship. And so that is something that you need to do. Sorry, I just looked at my phone. I got a call and text, which I'm not obviously going to take now, but I'm litigating a case and I had to send someone else to court this morning on it. And so you can see these things really do play out. This is a case I've been litigating for years, not an attendance policy case, but our decisions with respect to these are something that are actually litigated and that our litigation teams at Ogletree handle. But the EEOC wants you to promote flexibility for people with disabilities. It wants you to do what you can to give reasonable accommodations for people with disabilities, but you have the power to define what those are. Let's look at a couple other case studies. This was a real case, and this one did come to a resolution that I'm aware of. An asthmatic employee worked for a retailer for about 8 years. She was absent for 1 day without notice due to an asthma attack that sent her to the emergency room, and she didn't give the employer notice of the absence beforehand, right? Because she's in the emergencies room. Now, allegedly, according to the EEOC, the employer's policy allowed for absences for disability-related reasons, as employers must, it's required. But the employer discharged this employee 3 weeks after the absence, which I'm wondering about. Why did it take so long to address this issue? Delay causes risk. If there's an issue with an employee's attendance, we need to get on it right away, understand what is it the employee did it violate the policy, and do we need to move to next steps? It shouldn't take 3 weeks to do that. That can cause different problems. It can cause other problems in the work environment. Maybe there was that here and we don't know about it, but that case resulted in a $75,000 settlement. The EEOC reminded us the ADA requires employers to reasonably accommodate disability-related absences that enable employees to perform their job. And that's the key when I'm helping companies through absence and attendance issues and there's a disability involved. Are the absences enabling the employee to perform the essential functions of the job? If the employee needs to be gone indefinitely, can't give us an idea of how often they're going to come and go, then they probably can't perform those essential functions. So when you have disability-related absences and you're assessing whether they should be counting against your attendance policy, ask yourself, is the absence for a reasonable period of time? Because you're only required to give reasonable accommodations. If it's indefinite, that's not going to be reasonable. If someone says, I'm gone and I don't know when I'm coming back, how is that a reasonable accommodation? But you can only know that if you ask the right questions to get that information. Get verification from the medical provider on that. And often you may need to write a customized letter to the medical provider, give it to the employee, and say to the employee, hey, we need verification that you have this issue, because we can't tell by looking at you if you have it or not. We don't know. And we need verification on what's a reasonable amount of time off or anything we can do to enable you to be here in the workplace. Look, lawyers can give you forms, right, that you can use for disability-related accommodation issues, but you need to know your policies, and you probably need to ask customized questions. Doing a swift investigation. Why was the employee absent? Was it for a disability-related reason or for some other reason? And then using common sense, right? The scenario I just gave you where the asthmatic employee is saying she's in the emergency room, if we've done our job at getting what the story is, it probably doesn't make sense to discipline her for that or fire her for that, especially after she's worked there for 8 years. But I see that a lot. This sort of, this is our policy and that's what we're doing. And I get it, but think about how it would play out in court. Is it something that we can explain to a jury that, yeah, we were confident about this decision, we're compassionate to our people, but we need to be candid that we are going to enforce policies and we have good reasons to do that. So consider those things. know the ADA, right? Know that taking time off can be a reasonable accommodation, and you need to be thinking about how often is going to be reasonable when the employee presents you with absences related to an ADA disability potentially. And again, how much time may depend, right? It may be reasonable to give employees 6 months off, right? The EEOC has said that 6 months could be a reasonable time. They've taken that position depending on the job. How fungible are the duties? Could we just say, look, we don't feel that we can give you health insurance right now because there's no definite return to work date, but when you want to come back, just come on back. We've always got openings for these positions, right? If it's that kind of job, a long amount of time off might be reasonable, or at least if you're severing the employment relationship or severing the health insurance, telling the employee, look, we understand you can't work right now for a long time. We're going to need to have other people hired and doing that job, but just come on back when you're ready and let us know. And we believe we're going to be able to pretty quickly get you back into the pipeline. That's a strategy that you can take to sometimes say, look, we're enforcing our attendance expectation here, but at the same time, if you need to come back later, we'll be open to that, right? So think about how you might do that. Know the Fmla as well, because that's another statute that could cover absences. If you have 50 plus employees, you need to be assessing when people are gone due to serious health conditions, are they Fmla eligible? If not, we shouldn't be giving them Fmla. You can give them ADA leave potentially, because you don't want to give them the protections of the Fmla if they don't apply to the employee. You only want to give those to Fmla eligible employees. Eligibility depends on how long they've worked there, how many hours they've worked, and how many employees work within that 75-mile radius. If the person's eligible, then after that, you're going to assess, does the person have the kind of serious health condition? And you're going to go through a medical certification process to verify that they need that, okay? USERRA is another big one. So when employees who are serving in the military need time off, they generally get that, right? There's a very generous leave right for employees who serve so that they can serve and then get their jobs back and get reinstatement when they come back. So that's something to consider. If someone's gone for military reasons or even gone for years and years, you may need to reinstate them when they come back, including bumping other employees potentially. Pregnancy Discrimination Act. Our federal pregnancy law does not have a leave entitlement, right? The subject of much debate in our country politically. Should we give or require companies to give paid leave for pregnancy? Pregnancy can qualify for the Fmla, but know that you, under the Pregnancy Discrimination Act, there's not and it does qualify for Fmla leave, but there's not explicit leave or paid leave requirement, but you do need to treat pregnant employees the same as you'd treat any other person, similar in their ability to work. So if you make light duty available because of workers' comp injuries, you need to potentially make that available to others. Also know the rules in your states where you operate for the different types of laws that potentially apply and cover absences for employees beyond your attendance policy. So someone's gone in Illinois because they're dealing with a domestic violence issue, they may get leave under Illinois' law that provides for a leave entitlement beyond your attendance policies due to that type of leave. So don't count those attendance points that may qualify under your particular state laws. And there's lots of good surveys out there online that you can look at to get the flavor of what laws apply in the states where you operate. And finally, of course, your policy needs to address what the consequences are for violations. For non-protected absences, what's going to happen? Again, are there defined consequences or less defined, right? You may say in your less defined policy, if you have attendance issues, it's something we may put you on a PIP for and modify more closely. I think that can be a good strategy. When someone does violate your attendance policy, present it to them. Present them with the rule, explain the issues, present them with the dates they've been off or absent or tardy, times they came in if you have that, and clock-in records, and explain why the policy's been violated. Give the employee every opportunity to explain the attendance issue. If it's a new explanation, why is that just coming up now, right? Investigate that, document that it wasn't made at the time, and talk to the employee about that. Why wasn't this issue raised earlier? And make sure the consequences of future violations are explained, not just for the employee, but practically. We don't want to just have policies and rules for the sake of having them. Jurors don't like that. But you do want to be able to show and document this creates issues for us when you're not here, and make sure you're explaining why those are so we can, be on top of telling employees, hey, this is not just an arbitrary rule. This is important, and it's unfair to others when you are not here. I also generally recommend after these conversations, documenting it in writing to the employee, right? Giving them, even if it's a verbal warning, something in writing showing when they were absent, what the issues are, have them write down their comments, send them an email memorializing the discussion and what happened at the discussion so that you have that record later on of what was said and you can document when it happened, right? That's going to create documentation that we can point to later to say, hey, we talked to this person about the issue, we let them know what it was, right? So I talked about FMLA and notice requirements. So let me talk about, again, how important that can be with a case study. So an employer had an attendance policy, it was in their CBA, and it required employees to promptly telephone notice to their supervisor that they needed to be away from work. An employee failed to call in several times, resulting in points under the attendance policy. The employee sued for various reasons and various types of discrimination. The court said, nope, I'm looking at this policy. I see they have the documentation proving it was violated. So that case was thrown out after about a year of litigation. Here's another one. An employer, here's a really interesting one, required employees to give notice in 2 different ways if they need to be late. 1, call the operational unit, let them know you're not going to be there so they know there's an issue. And then 2, call our benefits hotline. Why? Because they're the folks logging the attendance issue. The employee failed to do that first thing, failed to give notice before the absence to the operational unit. What the employee would do is call that benefits unit later on after and say, hey, I was absent today. And it was fine to give the benefits unit notice later, but the employee needed to give the operational unit notice first so that they would know who's showing up and who's not. The employee failed to do that and argued in the lawsuit later on, look, I know I was discharged for this, but look, I called the benefits unit, that should be good enough. What the court said was, no, you do need to call the operational unit, and the employer has proof that you did not do that on all these dates because the operational unit was logging, right, when people were calling and when they weren't. So again, that's the kind of documentation that can win lawsuits. Hopefully you have a flavor and idea, having watched this now and listened to me. How are courts looking at this? They may treat your policies like the law. If the conduct of the employee does not directly violate the terms of the policy that you wrote down, a court may say, well, wait a minute, the employee didn't violate this as far as I'm seeing, or they're saying they didn't, and you don't have documentation that shows you believe that they did. Did you terminate this person because of discrimination? Well, they may send that issue to a jury to decide. Every absence matters. Documenting every absence matters. Every notification matters, and when it happened, down to the minute and what the employee said. Who said what and when, and how are you logging that using your electronic or other systems? Inconsistent treatment of an attendance policy can also lead to problems, right? If you're only applying it to certain employees and not others, that's something that the employee may attack you for. If you have a points-based policy, that may be something that you can address. So again, assessing really points for disability-related absences is one of the only potential issues that you can come up with. Now, as we come to the end, I have these samples that I've put in here for you. And if you email me after this or add me on LinkedIn, that's the easiest way to get in touch with me. Search Andrew Metcalf on LinkedIn. I know you've been multitasking on a browser anyway. Search me, add me on LinkedIn, and then ask for these policies if you want them in text. But this is a flexible policy, right? It generally doesn't set exact, requirements and doesn't set exact points. But it does say at the very end that, look, if this gets excessive or chronic, we're going to put it under the microscope. We're going to look at whether we need to deal with this. It also has a requirement that employees notify before the shift. And you should generally let people know in these policies, look, notifying is good, but that doesn't excuse the attendance issue. And that's a big problem that employers have with these is they say, employees say, well, I called beforehand, so it was fine. It was excused. No, it's not. It's not okay that you missed. It is less of an issue if you let us know than a no call, no show. So that is one type of policy. Again, here's an example of a much more detailed, and this one goes over several slides, policy that is way more defined that I'm happy to provide to you as well. So, it addresses no call, no shows, and it specifically says how occurrences are logged, what constitutes an occurrence, and what's going to happen. What is going to happen at each level of discipline. And so this is another type of policy, again, that's going to define all the different types of attendance violations and what's going to happen and what the consequences are going to be specifically. So this is something that I can give you again if you want, but I'm not going to read through in detail because no one likes a reader in these presentations. So my bottom line takeaway for you is, oh, and then sample discipline here. Again, you know, I think you need to be documenting this in writing, telling employees not just, you know, what the expectation is, but why it is important. So we can show that to a jury later and just say, look, we don't just enforce rules because we're a big mean company that has rules. We enforce them because they affect other people. I think we need to show that, right? And that's what the good modern day attendance policy is going to establish. Jurors don't want arbitrariness. And you see this in the media too, as you're reading reviews about companies. People complain when they feel they're treated arbitrarily. You may not feel that way, but the more that we can document and show that we're not treating people arbitrarily, the better off we will be. So this is, again, sort of a sample of how that can go. So here's my sort of closing remarks, and then I'll answer any questions you have. You can implement a robust attendance policy for both non-exempt and exempt employees. You may have different policies for different types of employees and different classes of employees. Whether you should have this kind of policy is worth considering. How are employees going to react to you throwing this down to a group of leaders, you know, sitting up on our high horse, right? Telling people, hey, suddenly now you have this policy, right? Are you going to let people know it might be coming and that changes might be coming so that they can mentally prepare for it? Are you going to have a policy that works for the flexibility that you want them to have to be adults and do their jobs, right? That's something that you may want to consider. Do you want to reduce risk, again, by gaining that robust understanding of why people are absent? Even if you have one of those evil no-fault policies, are you going to make sure that you're asking people, hey, okay, you were gone and you're not at fault. We're just going to assess the point and move on. But why were you absent, right? Are you doing that so that you can make sure and getting the reasons so that you can make sure that if it is a disability-related reason, that triggers the interactive process, and you can ask the employee, hey, do you need a reasonable accommodation here? You know, and then again, enforcing notice, right? That is a powerful thing we could do to say, look, I get it. You can be gone for FMLA. You can be gone for intermittent FMLA. You can be gone due to disabilities. But if you could have given us notice earlier and you're not doing it, that's a problem. And we're going to hold you accountable to that. So that's something that you may want to do. And again, often I'm seeing when employers are saying, oh yeah, this person's out for a disability related reason, we don't really understand why, getting more information from the doctor about what's needed, getting more information from the employee, and making sure that you get proper notice can really quell issues. And then not sleeping on discipline. If there is an issue, we need to address it right away. We need to deal with it and not let it sit, because that is what creates risk. So I speak a lot on these issues and others around St. Louis and otherwise. I post about all that on my LinkedIn. So I'd really encourage you, hop on, add me on LinkedIn so that you can see other stuff that I present at. And I'll be more than happy, again, if you want copies of those text policies, to flip those to you as good examples for you to use, if that would be helpful to you as a resource. So with that, Aaron, I'll open it back up to you. I haven't seen any questions come in the chat, but it can be hard to see.
Yeah.
So thanks so much, Aaron, for having me, and anything else that we need to discuss?
Yeah, thanks so much. So if you guys have questions, now's the time to do it. Type it in your question pane. I did see a few comments coming through. We will be sending the reporting out of this presentation later on this afternoon. So you will receive that to go back and review if needed. And then, you know, Andrew, thank you again. I like you sharing those case studies. It helps us put ourselves in the shoes of those scenarios. And definitely in the line of business that we're in, we have seen lots of challenges with attendance, and, you know, definitely relating to retention and, you know, COVID, which is the word we hate using these days, but it's definitely brought about a lot of workplace changes. So I can only imagine with your line of work. And then, you know, some things that we see is just really wanting flexibility in the workplace. So that brings a whole nother bout of things to talk about. But thank you today for providing the information that you shared with us. I do not see any questions. And if, you know, everybody that joined us this morning, if you want to make sure that you are on our webinar program in the future and you are getting those invites, you can, like Andrew said, I'm welcome to connect on LinkedIn. And you can also email me at hello@higherlevel.com and make sure you're in tune with what's happening. Our topic coming up in March, we do these once a month. We'll be covering hot employment law topics. So we'll see kind of what's hot during that time, and we will run with it and share that information with you all. So thank you again, and everybody have a good rest of your day.
All right, thanks so much, Aaron. Great being with y'all.
Thank you. Have a good day.